Chairman. We're having a hearing today because the Supreme Court did something very ordinary. So I'd like to say that again so it sinks in. We're having a hearing because the Supreme Court did not do something extraordinary. It declined to intervene on an exceedingly expedited basis while reserving judgment on complex legal issues. Much of the talk about the case has referred to the court's so-called shadow docket. For a long time, the court and its practitioners have called this the emergency docket because it is designed so the court can provide relief in emergencies. A good amount of these orders have historically dealt with last-minute death penalty appeals, but we didn't hear complaints from the liberals in the Senate about the docket for those cases. So rather than rely on a catchy name invented by a law professor, let's look at what the Supreme Court actually said in its decision September 1. In that case, the plaintiffs waited several months to sue after the law was passed, so the court did not have much time to work through the legal issues in the case. Having not succeeded in the lower courts, the plaintiffs asked the Supreme Court to grant them emergency relief. A majority of the justices on the Supreme Court said that the abortion providers had raised serious constitutional questions. They did not prejudge the issue, but they acknowledged that the plaintiffs had a serious case. But the court also said that the case raised novel procedural issues. It noted that under current precedent, it was not clear that the plaintiffs could sue the defendants. The Texas Heartbeat Act specifically prohibits several of the defendants from enforcing the law. Instead, private parties can do so in court. The majority noted that this system raised novel legal issues, and everyone seems to agree on that point. The Supreme Court said that it wanted the lower courts to address these novel issues before the Supreme Court addressed them. There are also at least 14 suits in state court and the federal government suit against Texas. The courts are addressing the legal issues on an expedited timetable. Those cases will work through the lower courts. I'm looking forward to hearing more from our witnesses today about how the Supreme Court's decision fits with this normal practice. But before I listen to that, I also want to talk about why we're having this hearing right now. The Texas Heartbeat Act was signed into law in May. There are hearings in state and federal courts this week and next about whether courts should grant relief. The abortion providers just asked the Supreme Court to provide the case or to take the case on the merits without wanting or waiting for a court of appeals. So why are we having this hearing at the last week of September? It's because the Supreme Court starts hearing cases next week. And this term, the Supreme Court has agreed to hear a case about a Mississippi law on abortion. The law protects the lives of unborn children by prohibiting abortions after 15 weeks except for medical emergencies. Mississippi said it enacted the law to protect the health of mothers, the dignity of the unborn, and the integrity of the medical profession. Of the 59 countries that permit elective abortions, more than 75% do not allow elective abortions past 12 weeks of gestation. But abortion activists are worried that the Supreme Court might agree that states can regulate abortion at 15 weeks. Liberal dark money groups are also worried about that result, and they believe that a public campaign can influence the Supreme Court's decisions. These groups have been publicly celebrating polls that show that the public's trust in the Supreme Court has dropped. So why do polls show that public confidence may be decreasing? It's because of dark money groups like Demand Justice are running multi-million-dollar partisan smear campaigns against our Supreme Court. It also is because senators on the other side have threatened the Supreme Court. They've called out justices. They've done it by name and said that those justices will pay the price if they ruled the wrong way. If the justices reached the wrong result, they were told, quote, "You won't know what hit you if you go forward with these awful decisions," end quote. Other dark money groups, partisans, and activists undermine the court by claiming that Justice Barrett's confirmation was an illegitimate process because one of the Democrat witnesses, including one of the Democrat witnesses we have today. Democrats and partisan dark money groups love to predict the future. They certainly don't lack confidence in their predictions, but those predictions are not very good. Democrats claimed that voting for Justice Barrett was voting, quote, to strike down the Affordable Care Act and eliminate protections for millions of Americans with pre-existing conditions, end of quote. Judge Barrett, according to them, was a judicial torpedo aimed at those protections from Obamacare. That scared a lot of Americans, but it sure wasn't true because Barrett joined the court's 7-2 majority that upheld that law. Some Democrats have said the courts need to, quote unquote, heal itself before the public demands that the court be restructured in order to reduce the influence of politics. That's a fancy way of saying that if the rulings don't, they'll try to pack the court. This campaign against the court and against individual justices has hurt the public. The dishonest rhetoric doesn't help the American people understand the issues. I'll continue fighting against the partisan efforts by dark money groups to attack our judiciary. There's one final point I want to raise today before we hear from the witnesses. The House of Representatives just passed a bill that could allow abortion on demand. It would preempt numerous pro-life state laws, and it would throw out the protections of the Religious Freedom Restoration Act. If Democrats truly believe that the court will overrule Roe, they should have a hearing on that bill in this committee. The American people would see how radical that bill is. Contrary to the outlandish claims by abortion activists, the Supreme Court did not overrule Roe. I think our witnesses today will explain this and offer some much needed information about the role of the emergency docket of the Supreme Court. Thank you.